All right, so the employment side of COVID. So we're all reopening, right? And because of that, you're dealing with your workers, and there's a different element to this when you are running a business. You are thinking about the protection of your team. You're also thinking about the interaction with your guests and what kind of policies and everything that you can have in place there for the actual team side of things. As an owner of a business, you do have some extra responsibility or liability to your clients and to their guests to kind of take reasonable precaution to ensure that they aren't being knowingly exposed to any illnesses. And so through the various documents, and we can talk through each of these, but that is meant to address it. So when dealing with your actual clients, the documents that are going to be important to keep internally are, the personal statement for your workers. And this is this would be for any person who is working on behalf of you. So this could apply to a contractor or an intern as well. In normal circumstances, there are certain policies and procedures that can't be enforced against a contractor in particular, but in this instance, this can. So, before each event, I would have them sign this document and then keep it in your records. Keep it in that medical file that we chatted about yesterday. So making sure that it's separate from your personnel files, but having a confidential medical file. And then you keep one of these on, have it signed every day before an event and keep it in that file. This is really meant to shift a little bit of the liability and responsibility to the person who is working, because it's them telling you that they don't have COVID, that they haven't been in contact with anybody who does. And this is to help in the instance where, let's say maybe you have somebody who's a worker who starts sneezing at an event. They tell you 4 days later, hey, I really wasn't feeling well. I went in, I tested positive for COVID. And then you have to alert guests, and then the guests come back and they, claim something. This shows that you've taken reasonable care to check in with each of your workers before bringing them into a public setting in which they would be interacting with guests. So that's what this document is for. The independent contractor release. This is for the contractor to release you from any liability. Okay, so this is them saying, or you saying to them, here's what we're doing. Here are the steps that we're taking. If you come to this, you are knowingly, sorry guys, turning off Sesame Street there. That if you come, to this event, if you choose to work, that you are doing so knowingly and you're assuming the risk of doing so. With signing this release, you are indemnifying us of any liability if you are to get sick. Okay, then we've got, I'm going to try and do these in somewhat of an order. The temperature personal statement. So this would be also another document that you would want to have everybody sign before they're interacting with your guests or clients. And this is essentially saying, I don't have a temperature. Temperature seems to be such a big deal. And so many businesses that have client interaction have a temperature check incorporated into their policies, that I would imagine that will be something that people will be looking at in the instance of any litigation that were to come out of this. And so, this is where you don't have to take their temperature, but this is them saying they don't have the temperature. Again, that stays in their personnel file. Before we get into handbook, because that's going to be a bit of a beast, I want to just keep going through these. Disclosure to client, we've talked about that in reference to your client documents. If anybody does get sick, letting your client know. This is you're not under an obligation to do that. However, you kind of want to weigh the situation there as to, you know, if there is contact tracing, does it feel better as a client to get a document from the you know, vendor or planner or venue, whoever it is, saying, hey, heads up, this has happened. You know, we wanted to let you know just in case you wanted to go get tested. Or does it feel better for them to get some type of notice from the government? It's tough. It's probably going to depend a little bit on the side of who the client is. I personally would probably rather hear from the business. To me, it would show like, okay, they're taking proactive measure. They care. It doesn't open you up to any further liability to do so. But you could also end up with some rogue person who's like, you know, blasts on social media. Oh my God, if you were at this event at this venue, then we got COVID. So, you know, it's kind of it would weigh the situation based on your client interaction and kind of their personality and how they've been so far. Business continuity plan. This has to do with, it's twofold actually. Okay. So this has to do with allowing your team internally to feel like they're protected. You've thought through this. You know, I'm looking at everybody who is here with us today, and every single one of you is integral to your business. Meaning, you know, whomever works with you looks up to you for structure and continuity, and you have, you know, a managerial role in your business. The business continuity plan addresses if you get COVID or if you get something, you know, similar to it that knocks you out and makes you feel, you know, pretty sick, and you're not able to participate due to the potential infection of COVID if you're waiting for a test or something like that. So it's going to allow your team to have structure and direction as to what to do. You know, you can assign who is going to be in charge. You know, it doesn't necessarily need to be somebody who is in your company. You know, if you know, a planner is great friends with another planner and you guys kind of agree, hey, you know, if this were to happen, you know, I'm going to ask you to step in, you know, I'll give you whatever, I'll give you a cut, whatever it is. But it gives direction for the team, and it kind of cuts off the potential conflict at the knees of different people assuming different roles and then disagreeing with each other. And it keeps your business going forward in the way in which you intend it to go forward. The other side of it is that a business continuity plan, although is not required by law, it is best practice at the moment, given the gravity of COVID and how quickly it can hit and wipe you out. And so if you were to have this, not have this in place and something were to happen, let's say, you know, you don't have, you get sick and you don't have anybody in place to run it, you don't have a continuity plan, and, you know, your people are kind of flailing and things get missed. You know, food is delivered late, the cake is not delivered, you know, I don't know, the venue's not open on time. There is, you know, day of planner gets there late. This again helps protect against claims that the client could bring against you for being negligent and not being properly prepared in this situation. So helps protect you for claims made by a client. Also gives security to your team that everything will move forward as planned in kind of the worst case scenario. One thing that nobody wants to think about at all, but of course lawyers do, you know, is, and if you haven't addressed it, is something to address, is, you know, the worst case scenario. If, you know, something happens to you permanently, what happens with the business? How does it keep running? I talk about this all the time with my dad, you guys. I'm sure he doesn't want to contemplate death at all, but I talk about it because I'm like, look, here's the deal. Like, if either you or I die, the other one is going to be like out of commission for a solid year. And so, you know, we've got all sorts of stuff in place with other lawyers, agreements with other lawyers, both of his vintage and mine, because it is important to kind of think about that. And that, yes, it relates to COVID in the sense that there's, people getting sick and dying every day, but that also just relates to life in general. And because we are now in the time of COVID and being forced to kind of reevaluate all of these things, it gives you the opportunity to think through that. So I would process through those things when you are working on your business continuity plan and revisit whatever you have in place that may address that. I see that a number of you have quite established businesses, meaning you've been around for a while, and probably transitioned from old LLC law to new LLC law. So if you didn't update your documents at that time, you would probably want to do so, since that would have an effect on things like your business succession, if anything were to happen. So that's just a kind of a extra tidbit side comment there. Okay. And we'll answer any questions. Happy to talk about ideas for things like this. Whatever it is you guys want to hear, I'm happy to talk about. Okay. So the emergency response preparedness plan, this is just a, modified version of what the government's provided. But what I will say, you guys, is, and I mentioned this yesterday, is we have been working on, Brooke has been working on putting together one that is very specific to the wedding industry based on the actual language in that executive order, as well as in the additional order that was released on the 12th. It is currently being reviewed by Jim, and then it will be going to that smaller group for the Minnesota Events Coalition to kind of think through things and get some other perspectives from people who are still in the industry, and then that will be available to everybody as well. So we will send you that document too. That's more meant to have consistency across the board, so that you're not, dealing with the situation in which, you are trying to comply, you are encouraging compliance, with your team. And then all of a sudden you've got kind of team members from other vendors contradicting your team, and there's just a whole bunch of confusion. So that will be going out as well. Okay. The employee rights poster. If you have employees, there are different posters that you need to have posted in your establishment, or if you don't have an establishment that you need to provide to them, like a Google file could work, where they all have access to it. This is a new poster that needs to be included and needs to be put up for the sake of your team. So make sure that you do that. You could also, when you're sending them maybe an updated handbook or updated COVID policies, you could attach this to it, and you could let them know, hey, this is the new employment rights poster. Make sure that you review it. And that just shows that you're being proactive and you're being fully informational with your team. Okay. The handbook clauses. So, most of the time, handbooks cannot be used with contractors. It's mostly for your employees and sometimes for your interns. Now, at the moment, a lot of kind of rules around that have faded away a little bit because there's so much focus on public policy and on protection of the public at large. And so a number of these that are in here probably can also be applied to contractors. You wouldn't want to include it in an employee handbook to them, but you could put together, a COVID policies manual that you give to anybody who you are working with during this time until, everything is lifted, which who knows when that'll be. It could be next year. It could be the year after. So it could be kind of a document that you have in place indefinitely until there are significant changes that come down by the government. Okay, so I'm going to walk through these, and questions are for sure going to come up. I am confident of that. So don't be afraid to ask. Also, I want to note with your COVID policies, once once this document comes out from us with the COVID policies, you will feel free to personalize that to your business, and then included in the employment package that you have purchased is review and feedback and editing from us on that. So feel free to, take the document, personalize it to you, and then send it to us for review so that you feel really confident with that. Okay. All right. So the provisions. So in the documents, you'll see that the green provisions are meant for kind of talking points with us and information for you. They're not meant to be included in the policies that you give to your team. The black provisions are clauses that are to be included, and then the blue are considerations for you pertaining to those clauses. So kind of starting off thinking about general workplace safety considerations. This is where you want to think big picture when you're coming up with those policies that you are going to implement in your business, and think about it on all three levels. So think about it from an employee perspective and a worker perspective. Your goal there is to ensure that there's a solid plan in place to maintain a safe workplace and a healthy workforce. Obviously, you can't guarantee complete safety, but that is, your overarching goal. So you want to, consider your communication with them, keeping things open, having a point person who they can talk with, keeping signage up, and then, really encouraging communication rather than the fear of communicating with you guys. Allowing them to know, hey, we are all in this together. If you ask us questions, there's not going to be retribution. We really encourage that type of environment is going to be important. And a reason why, and I think we do get into this further, but there's been a lot of chatter around disability and what COVID will mean for employees claiming disability due to mental distress as a result of COVID. And so creating that environment in which they feel they can talk with you about anything without fear of reprisal, and documenting that you've done that is an important step to take, because you don't want a situation in which somebody says, that they've been suffering mental distress and now they've got, this might be odd. It's known to me, but it's not, I think that's only from litigation, but, a very common claim is that from mental distress, there's been, irritable bowel syndrome is a really big one. And that's because there has to be some physical manifestation in order to claim damages. And so that's one that's like kind of tough to monitor, but it is something that can happen. So you just don't want a situation in which, somebody comes to you a year from now and is like, I've been so distressed and I've been fearful, that you're going to fire me and I don't want to talk to you, but I've been suffering these medical damages. Are you going to pay them, or do I have to come after you? So, or a bad PR piece on, working for a company that's not being supportive during this time. Now, there's a balance there, right? You don't want to be taken advantage of. But again, we'll get into that in a little bit here. Management and supervisors. So, special attention to them, to preparing members of the team who kind of will step into those roles and enforcing new policies, and establishing within the business and within your team pool at large, kind of like, here is, I don't want to say hierarchy because that's, I'm looking at everybody on here, that's not really kind of how we operate. You don't like to establish a hierarchy, but for the sake of purely using a descriptive word, you're making known the hierarchy so that people know who to turn to if you are unavailable. And then suppliers and customers, setting up your plan for them. Now, the other aspect of this kind of shift around COVID is that some other policies in your manuals or just kind of company knowledge can be affected by this. So you want to think about the way that your other policies have been communicated or are written somewhere, whichever it is, whether it's verbal or written. And those, would include, your regular attendance policy, your vacation, your paid time off, your remote work hours. That's a big one. Start, stop time, breaks, lunch, flexible hours, timekeeping, leave policies, travel policies, information technology usage. I think social media is probably another one that you would want to include on there. We've been dealing with a lot of calls about the ability to control social media messaging that goes out. So that is probably something you want to do. Maybe even, I didn't include this on here, but take note of it, like maybe volunteering, if they're, for example, the last few weeks, right? Like everybody's been volunteering like crazy. And you definitely don't want to be seen as the employer that's discouraging that. So maybe the process for how that is handled. So then moving on to evolving policies. This is something to include whether you are amending a handbook or you are putting together a policy document that's going to be in place moving forward. And this is just putting in there that this is an evolving time, both legally and medically, and that it gives you the right to change or add new policies as you see fit. I should note that this is written with your business being referred to as the employer. If you are going to put together a policy document that you're going to be giving to contractors as well, you may wish to change that word from employer to the name of your business, so that you're not inadvertently suggesting an employee-employer relationship. And I mentioned that kind of twofold. One, so that, if you end up with somebody who is aggrieved, they can't come back and saying that you were misclassifying them, and then you end up in like a Mary Kate, Ashley Olsen situation, owing tons and tons of money. And on the flip side of that, if you were to receive PPP or other types of loans, you're more likely subject to an audit sometime in the next few years, and you don't want to have a document that says employer when they were contractors, and then open yourself up to potential misclassification allegations, and then back taxes and back wages. So just change that word employer to the name of your business if you are putting together an actual policy document instead of putting this in a handbook for employees. Reintroduction meeting and policy overview. This is going to be an important thing that you do with your team, so that you don't have a team member who says that they were unaware of the new policies. I'm sure that will be a big point of contention over the next year. So if you can have, a mandatory meeting, and, you're reintroducing your team to the workplace and going over the policies with them. And then you kind of take note, like, here, this is the date that the meeting was, here's who's present. That allows you, essentially tangible evidence to argue back if they say that they weren't aware of the new policies that were in place. In most cases, you cannot require mandatory meetings for contractors. However, I would think that in this scenario, it would be okay if it's a contractor who is regularly working with you and interacting with your clients, that it would be okay to have a mandatory meeting in that situation. You would want to be paying all of these people for that mandatory meeting, but that's a small price to pay for the insurance that gives you. Regular team check-ins. This is, again, kind of best practice, and it's going to those likely future claims of mental distress or disability. And it's just saying this proves that you are kind of an open workplace, like, hey, let's have a monthly Zoom to just check in and see how everybody's doing. I think probably a lot of people do that anyway. So just having that written, and then, making sure that you do it and just keep keep a note of like, here was the Zoom meeting. And you can tell people that either is mandatory or not, so long as you're creating the space for them. That is what is important in this situation. Okay, workplace illness. If an employee or worker is exhibiting symptoms of COVID-19, and I include in here, or an influenza-like illness, just because who knows with testing and who knows when it can get back. You may ask them to either stay home or, if present at work, take leave until cleared by a medical provider to return. You could also say medical provider or you, whichever is longer, but that is something to have in there. And then listing here the CDC symptoms, so that you actually have an outline of the symptoms that you're looking for: fever, fatigue, cough, sneezing, aches, pains, runny, stuffy nose, sore throat, diarrhea, headaches, shortness of breath. Additionally, that you would release any other workers who have been in close proximity with the potentially ill person, and monitoring the workplace, so that you're watching to see if there has been any spreading of any illnesses. If you become aware that somebody has tested positive, then, beyond the different requirements mentioned above, meaning that you can, send them home and ask everybody else to stay home. Then this outlines, your next steps as to how you will handle that situation, and what timelines will be put in place with regards to the onset of symptoms. It also says in here, just as kind of a catch-all, that you can reference the CDC recommendations for most non-health businesses that have suspected or confirmed COVID-19 cases. Again, as you're reading through this, where it says employer, and if you're going to do a COVID policy that is going to apply to contractors and interns as well, you may want to do a word search. And when you switch employer to your business name, you may also want to switch employee to worker, so that it can be applied to contractors and interns as well. So we have a note in here. If employee refuses to leave work, we would encourage, it's like, okay, what do you do in that situation, right? Because now you're thinking like, oh my God, the guests. We've also got, our other workers. Is everybody going to get sick? If you work in the food industry, it's like, okay, it's all of this food contaminated now. So if they refuse to leave work, then we'd encourage first taking the collaborative approach, reminding them of why you're asking them to leave, that they're not in trouble, but that you're doing it for the safety and well-being of other individuals. And, if there are benefits available, if you're in Minneapolis and you've got paid sick leave, or, if there's accrued vacation, that can help appease them. But you should explain to them kind of first, hey, I hear you. I get that you want to work. This is not reprisal against you. This is, kind of in line with the CDC guidelines. And we're just trying to execute this so that you can get well, and that we can keep the rest of the team well. If they still refuse to leave the workplace, you can consider, explaining that they're now trespassing. That's an aggressive approach, but you can do that. You could also terminate the employee for subordination. If you are in a difficult situation and somebody is really being stubborn and not wanting to leave, and you don't want to threaten termination or trespass, you can also shoot me a message, and we can do one of two things. Is I can either, respond to you, letting you know what my recommendations are, and then you are welcome to convey that you've spoken with your legal counsel and this is what they are recommending at this point. That should be kind of a little bit of a nudge. Otherwise, because I work with you guys, I can't offer, facilitated resolution with any of you in particular. However, through the ADR collective, we've got, a dozen other mediators who can, we don't just mediate like major disputes. Like we can come in and kind of be a peacemaker or a bearer of bad news kind of thing, which many people will opt to do so they don't create a rift within their company. So that's another option for you. Okay, you can, the green here, you know, it goes into detail an employee's refusal to return to work. This is, you know, up to you as to whether or not you want to address it with people. I don't know if I would, because you don't want to plant the seed in their mind that they could refuse to return to work. But this will give you information on if there is a refusal to return. So they are only entitled to refuse to return to work if they believe that they're in imminent danger. So this is part of OSHA, and OSHA defines imminent danger to include any conditions or practices in any place of employment which are such that a danger exists which can reasonably be expected to cause death or serious physical harm immediately or before the imminence of such danger can be eliminated through the enforcement procedures otherwise provided by this act. They do discuss imminent danger as a threat of death or serious physical harm or a reasonable expectation that toxic substances or other health hazards, you know, could be present there. So here the threat must be immediate or imminent, which means that an employee must believe that death or serious physical harm could occur within a short time. In many cases, you can rise above that. You know, I mean, yes, people are dying from COVID all over the place. But here, it is the employee's burden to prove that that is what's happening. So if you are taking all of these reasonable measures, if you have your preparedness plan in place, if you are doing sanitizing, you know, if you have an employee who says, okay, I really am not comfortable, you know, communicating with guests, okay, fine. You know, then you kind of do the backroom stuff. You do setup. You can wear rubber gloves. You don't have to communicate with many people at all. You know, if you're second shooting or something like that, you know, you can be carrying equipment. You don't have to have the interaction. And you can, you know, work to adjust expectations with them. But so long as you are showing that you're trying to create this environment for them, that's a pretty tough burden for them to overcome if they are asserting that they are refusing to come to work based on this issue. I just recently had some gals who work at a workout facility, and they were saying, we're not coming back to work, but we'll keep doing exercise via Zoom. I spoke with an employment specialist on this because the gym aspect of it gave me pause to think that maybe they had a little more standing than they do. But you know, the employment specialist who I spoke with, who I work with regularly, and who is one of our neutrals through the ADR group as well, he was pretty clear that unfortunately during this time that just isn't enough, because the government has said that gyms can be open. And so in that instance, it would be termination for insubordination unless they can prove that kind of physical manifestation that is a disability. So if you are having an employee who refuses to come to work, that is something to look into, rather than to, I mean, don't immediately say like, you're fired, you know, but you want to come up with a good way to explain to them that that just isn't going to be acceptable in this situation. So, and you'll see throughout this document as well that I've put in detail for you to reference in the red lines as well. And this is all collected through, you know, a variety of employment blogs and articles and CLEs that I've taken specifically around COVID here. Okay, so you're ultimately saying that you're going to follow the guidance issued by the CDC and OSHA to ensure that you know, your employees are not in imminent danger there. And one of those is talking with your employees about the working conditions, participating in these kind of safe environments where they have that open line of communication with you. So that is why we have that above language that addresses kind of that open door policy or the meetings that you're going to have. Okay, employees' right to refuse to do a task is protected if all of the following conditions are met. So where possible, the employee has asked the employer to eliminate the danger and the employer has failed to do so. The employee refused to work in good faith. This means that the employee must genuinely believe that an imminent danger exists. A reasonable person would agree that there's a real danger of death or serious injury. Unfortunately, from a human being perspective, fortunately, from an employment perspective, I don't really think that most of the people in Minnesota who you might pull on a jury think that there is any real danger or serious threat anymore, judging by kind of the lack of masks going on. So that's, what you would think about as a reasonable person is kind of who would be a lay person on your jury. And there isn't enough time due to the urgency of the hazard to get it corrected through regular enforcement channels, such as requesting an OSHA inspection. So, it'd be pretty tough for all of those conditions to be met in the event industry setting. So in light of the guidelines, recommending people wear face coverings in public settings. However, not recommended that you refuse an employee's request to wear a face mask at work. I think that it was made clear by the Minnesota government through the recently released document that anybody who's working an event needs to be wearing a face covering. So that's kind of covered there for you. Okay, self-reporting. If an employee, and this is a clause that you're going to put back in there. Okay, so, and this is where you're going to have, you have those other documents that actually facilitate compliance with this, which is going to be important. Self-reporting. If employee or worker begins experiencing COVID-19 or influenza-like illness symptoms within, you can choose the number of hours or days of being scheduled to work or at work that they must notify, and then you would want to put there who they're going to notify. If it's you, put your name. If it's not you, then put who they're going to notify. If employee has been exposed to someone who's exhibiting symptoms, then they should notify. Again, put your information in there. If they are exhibiting symptoms, they should remain home until released by a medical provider. If that's not an option, symptom-free for at least X days, hours, without fever, et cetera, et cetera. Again, this is where you're going to have those other documents that you have them fill out. And, even though this would be in their policies, you really want that signature and date for your own purposes to protect yourself. If any, one wedding ends up having people who were infected at it. So I put a little note in here based on CDC recommendations that based on research, it appears that an employee should be symptom-free for at least 3 days, and it should be at least 10 days after symptoms first appeared. CDC recommends discontinuing isolation if person may appear to, to discontinue quarantine for persons known to have been exposed. Based on the 14-day time period, but you can choose kind of what you want to do there. Again, the blue language in here is just for you. Green language for you, you would take that out. You would not include that in your policies. Okay. Workplace testing. This may or may not become a thing. Right now, it is not required that there be any workplace testing. I think that's in large part because of the lack of availability of testing. Now, this is something that I could reasonably foresee having become a thing if there is more availability of tests, especially in the events industry, right? As you could see, like if they come up with an immediate kind of test, you could definitely see even large music festivals like a Coachella being like, yep, get tested before you come in. I mean, anywhere where there's going to be a hot spot, right? So this is something that, it says that, it's not required right now, but you still have it in there just in case it becomes readily accessible, and you're having it in there so that you don't have to have them sign all new policies when that may happen. So it's saying that, you know, if there is a time when reliable tests become readily accessible and available, that you reserve the right to administer testing that's job related and consistent with business necessity, which I think it probably always would be for the event industry here. So this is just allowing that to happen. Again, it also includes in here that you may take the temperature if you choose to, and anything that is related to any outcomes of any testing needs to be kept in that separate medical file. Okay. If you're doing business in California, there are additional requirements. So if anybody's got any destination weddings out there, there are additional requirements that are subject to the California Consumer Privacy Act, which also, side note, there are, if you haven't updated your privacy policy in the last year, due to that CCPA, there are new requirements that you have certain language in your privacy policy on your website. So you want to get that updated as well. So your website privacy policy should be GDPR compliant as well as CCPA compliant. If you have anybody who's an EU citizen or California resident visiting your website, which probably everybody does. Okay, so then if you would, you know, like to be taking temperatures, you probably want to have one person who's designated to do that. They should have proper PPE that is supplied by you, maintain proper social distancing, you know, do have this in a sanitary area where it's not going to potentially infect anybody else. You're going to pay them to do it. And then you want to also acknowledge that, you know, you have a waiver with them because you are putting them essentially at risk of interacting with people who do have COVID. And so you want to have a plan in place if they were to get sick. All right. Coverage for testing for COVID. If they're on a health plan, the plan will provide coverage. I think that's required right now. So that's just a statement that you're giving people so that they can't say like, well, I don't have coverage. In Minnesota right now, right, everybody should be able to. I've had my own issues getting tested for Charlie, but logically and based on their word, everybody should be able to get tested. Masks in the workplace. So I have it written right now that you are required to wear masks, which actually does seem to be a requirement for actual events. You could add in some language here that addresses that if you're not at an event, that you may require different procedures, but this is kind of written in there that everybody has to wear a mask, and that if somebody believes that they have a medical condition that prevents them from wearing a mask, that you will engage in ADA interactive process, including, you know, a questionnaire with their treating physician to come up with another solution for them. Reporting COVID positive cases. So in accordance with OSHA, employer will record instances of an employee contracting COVID-19 if it's contracted while on the job. That's a tough one to tell, right? Because you don't know the exact point of contraction, but you know, if they've been working with you, then you probably do want to have that reported. Here's some language here about the medical file. Again, that this needs to be its own file that is only available to those who truly need it, which would probably only be you as the owner of the company or as the main manager there. Let's see, personnel file. You may or may not want to update your policy on the personnel file for employees. You wouldn't have a personnel file for contractors. You may for interns. So that is one. So far, all of these have been, all of these could apply to contractors, interns, and employees. Personnel file would only apply to employees, but you may want to update your policy on that. Cultural activities. If you are a company that has kind of regular activities where you're getting together, you may just want to put something in here that you'll make a determination based on kind of what is going on at any given time. There's some language here that you can use. It's more to help people understand that they you know, aren't obligated to come in if they are fearful, or, you know, that they are obligated to come in if it is like a mandatory meeting. COVID sanitation measures. Obviously, the preparedness plan that you're putting in place for events is going to be much more strict than you may have in place for like 3 to 10 of you who are in the office together. So this is, you know, you would want to list the sanitation measures that you are going to take for your team. But don't over obligate yourself here, because one thing that, you know, aggrieved workers can look for is anything that you did not do that you said you're going to do. And so, you know, when you're doing whatever your sanitation measures are, you want to keep a checklist of those. You want to have that dated and signed, just so that you have documentation, so that if somebody were to say, hey, they did not comply with all of these, I got COVID, you want to be able to say like, nope, no, we really did comply. Guest and client interaction. This is where you're going to outline how you expect them to interact with your guests and your clients. You know, there should not be a situation, it's been made pretty clear that there should not be a situation in which they're expressly asking a guest or client if they have COVID. But this can help outline the procedure and how you would handle that. I think that probably going to be important, because you could definitely see a situation at, like, let's say a wedding, and one of your team members is hearing somebody cough and sneeze, and they're, you know, freaking out about it because everybody's stressed out. And then they tell somebody else on your team, oh my God, like, did you see that person? I think they have COVID. I don't want to be around them. And then other guests kind of start to freak out, and maybe, you know, the couple or whomever it is who's hosting the event, they get stressed out. And then all of a sudden this person is like, I don't have COVID. I have really bad hay fever. And we live in Minnesota where there are cottonwood trees everywhere. Like, now we just ruined this event because you're, you know, concerned about it. So that would open you up to liability, right? For somebody claiming like, oh my gosh, you freaked out, you ruined my event. So in this situation, you want to just outline how they would come and talk to you if they had a concern. Rehiring and hiring screening. So in normal world, you would not ask people in the hiring process or rehiring process, you know, do you have a certain illness? You would not ask them about their medical history. You would not ask them about, you know, their race, their religion, their marital status, their relationship status, their, you know, sexual orientation. You would not ask about any of that in a normal hiring process. Here, you may conduct screening for job applicants and for those returning to work for symptoms of COVID-19 or any influenza-like illness. If it's done, it does need to be done for all persons in the position that you are bringing them back for, so that you're not discriminating against any one person, and only after making a conditional job offer. So in the same way that you have conditional job offers that apply to background checks, here you're going to have a conditional job offer based on COVID. So, and then employer does not discriminate against anyone based on, you know, race, religion, creed, sexual orientation, otherwise, yada, yada, just so that you're preempting any issues of somebody claiming discrimination there. Childcare. I've heard that there's been a number of people who are not necessarily vendors, but small businesses in general, who are starting to say, like, we get it, childcare sucks, like, you bring your kids here. This is saying that you cannot provide childcare given the licensing that is required, and if an employee is facing a childcare related issue, to contact you to discuss the matter. This is trying to help you avoid the situation in which an employee says, well, so-and-so is like letting their kids come to work. Can't we just have a little area set up for our 5 kids? It's just meant to protect you there. Travel, this is addressing travel bans and, you know, what you want to require if somebody has recently traveled, if you want them to quarantine after they get back, kind of whatever requirements you want there. Remote work. You know, we've written a remote work policy here. you certainly can edit this and address and make the changes to whatever works best for your business. But you want to look at, the procedures, the equipment, the security, time worked, how that's monitored. We have some additional information in here on, what you can do to prepare for possible remote scenarios, coming back again, if there is a resurgence, addressing here paid and unpaid leave for coronavirus-related reasons. And then the acknowledgement form that they have received this update of the handbook, or if you're going to do it as policies, just change the word handbook to policies, and make sure that you're changing out that employer-employee language to company name and worker. One question that has been posed to me is, what do you do if you can't keep everybody on right now, but you don't want to totally terminate them because you are hoping that things are going to turn around and you're going to be able to have them back? You can certainly furlough. Furlough implies a set amount of time. You can certainly do a layoff. Layoff still allows them to claim certain benefits that are available right now. And then, there is termination. You can also set up, in most of these instances, your team is going to understand. They're going to get it. Like, look around, the industry as a whole is hurting right now. And so, we want to make sure that you understand that this is not being done because we don't like you or because you've done something wrong. This is being done because we literally cannot afford to keep you right now. With that said, we want you here when we can have you here. So, let's lay you off or furlough you or terminate you. But then let's also establish a contractor relationship with you where we can offer to bring you on for certain events until this hopefully all resolves and you can come back as an employee. That should not have the same type of effect. In normal world, it would be like, ooh, does that complicate things? But during this time, that should be able to be effective so that they can still, get benefits that are available right now through the government, and you are still maintaining your relationship with them and they know that you still like them, because that's, of course, a concern. I've talked with some people who have been let go and, they're sad and they don't understand, but they do understand. And so it's all a very emotional time. So I think that, coming up with kind of a creative way that you can say, hey, I can't guarantee you anything. I don't know when you're going to come back. Here is a formal layoff letter so that you can, get benefits if they are available right now. But let's also, have you come in as a contractor when we can afford to do so. And that can kind of help alleviate that. Okay. Do you guys have questions? That's a lot of information pertaining to worker teams and bringing everybody back. And I realize that there might be questions. And if there aren't questions right now, you can certainly email me too. But what I would say is to have everybody sign those, waivers and disclaimers before they are interacting with anybody outside of your business, and then to implement either an updated employee handbook that you have a meeting that you walk through with everybody, or provide an COVID policy manual that is going to be applicable to everybody there. No questions? Okay, well, as you process, feel free to reach out if you are wondering about implementing, or if you, set up a team call and you want to have me present on the team call as kind of like the company attorney to be there to kind of make sure everything's running smoothly. I can certainly do that too. So you just let me know and we will be in touch. Okay, have a good day, guys.